I'm your host, Marsha Florence for Just Ask. Today our show is about your civil rights. Hurry back and join us.
Laughing on the inside.
Hi, I'm your host, Marsha Florence for Just Ask. Today our show is Your Civil Rights with attorney Ann Warner for Department of Civil Rights and her client, Claudia Kozlowski, and her son, Joel Kozlowski. Hi, ladies and gentlemen. How are you?
Hi, Marsha. Hi, Marsha.
Now, Ann, this is a very unique show for us, and we know this is the Department of Civil Rights. So I want to ask you, before we speak to Claudia, give me some information about Department of Civil Rights.
Okay, the Department of Civil Rights is a statewide department, and we are charged with enforcing the two major civil rights laws here in Michigan. One is the Elliott Larson Civil Rights Act, which prohibits discrimination in housing, education, employment, public accommodations, and public services on the basis of race, age, gender, religion, national origin, and I'm probably going to miss one or two categories. The other major piece of civil rights legislation is called the Persons with Disabilities Civil Rights Act. It's a separate statute. It also prohibits discrimination in housing, education, employment, public accommodations, and public services against persons on the basis of disability. It talks about reasonable accommodation, that employers have to make reasonable accommodation for employees if requested, and it's somewhat similar to the Americans with Disabilities Act, which is the federal counterpart to the Persons with Disabilities Civil Rights Act. As a department, we offer several services to the public, both disabled and non-disabled persons. We offer, of course, complaint resolution, where someone feels their civil rights have been violated and they come into the department to file a complaint. Then there's an investigation. If we believe discrimination occurred, we then go forward with that case all the way through a hearing, which is very much like a trial in the court system. And then there's an appeal to the Michigan Civil Rights Commission. There are 8 commissioners appointed by the governor. If the case goes beyond the commission stage, then it would go into the circuit court if either side is unhappy with a commission decision. But what else we offer the public is what we call outreach and education. We will go to an employer or a school district or a public accommodation, a landlord, and we will talk to them about civil rights and tell them how to avoid civil rights violations, how to comply with the civil rights laws. And for instance, under persons with disabilities, we might talk to a business about how to make their business accessible to persons in wheelchairs. Or we might talk to a school system about how to make sure that deaf children have adequate communication within the school system.
Okay, now, when you say you would go out and speak to these businesses or services, is it that someone calls you and asks you to come out, or do you guys just, pick some place to go? How does the two connect?
Well, we do it both ways. People can call in and ask for our service, but we also, I guess, solicit businesses is the best way to say it. Our director, Dr. Nanette Lee Reynolds, has gone to 22 cities in Michigan offering our services to the cities. And we are now about to start what we're calling ELC, Extended Liaison Communications, where we're going to reach out to businesses and other non-governmental entities in the state and offer our services to them. So it's both by request and by our going out and seeking the opportunity to do this. One example is that we recently went to Petoskey, Michigan, and gave a half-day seminar to small businesses and human services professionals, people who do the personnel within companies, the personnel directors, human resources directors. And we did a half-day presentation. I did an hour on sexual harassment law, how to avoid sexual harassment litigation, and how to set up a policy in your company dealing with sexual harassment. Then my colleague, June Atkins, did an hour and a half on diversity and how to deal with diversity both in your workforce and with your customers and clients.
Okay.
So that's just a sampling of something we might do in terms of going out and educating the public about civil rights.
Right, that's wonderful. I'm not sure if, if the public actually knows what all civil rights does and everything, and how to come in contact. I know you got an 800 number or a contact number.
Yes. If you call this 800 number, you will be automatically connected to the Civil Rights Office, the Michigan Department of Civil Rights Office nearest your home. And our number is 1-800-482-3604.
Okay.
We also have a website, www.mdcr.com. Available on our website is a poster that talks about what types of discrimination are against the law in Michigan. We also have something called the Pre-Employment Inquiry Guide, which tells employers and employees what questions can be asked
Wonderful.
by employers, legally can be asked by employers who are seeking new staff, and what questions are illegal to be asked.
Okay, that's a lot. And you know what? If people would just in general, before they either start a business or during the process of starting a business, seek out some of the civil rights services and much more, I think that before the business actually takes off, they would be better prepared for some of the obstacles that may come their way.
Yes.
And I don't think people do that. And I think more the older established businesses feel like, I don't need that, and yet things do happen, and then all of a sudden everybody's scrambling around looking for this and that, and it's just a lot of chaos. But you do a good job. You guys honestly do.
We try.
I understand. So we're going to turn this over to Claudia. And Claudia, we want to find out a little bit about yourself and your son, Joel.
Well, Joel we believe he was born with a congenital hearing loss, but it was much less severe then than it is now. He wasn't formally diagnosed with the hearing loss until he was 3 years old, and he has had a progressive hearing loss since that time. And right now he has no hearing in his left ear at all, and very little hearing in the right ear. It's probably about a 85 to 90% loss.
Okay.
And he wears a hearing aid in the right ear, and because of the progressive nature of his hearing loss, he was able to develop speech. He had a little window there when he was a toddler where he acquired speech, so he's able to communicate that way as well,
Okay.
but uses sign language mostly in learning situations.
Okay. So sign language is his primary communication?
Well, it depends on the situation. Socially, he uses his voice, but in a learning situation, he will rely on an interpreter.
Okay. Now, can you tell us about your relationship with Ann Warner here in the Department of Civil Rights?
Well, I filed the civil rights complaint, I believe it was in the fall of 1997, and dealt first with one or two investigators with the department, then the mediator, and then once it was determined that we could not resolve the issue by discussions, it was turned over to the legal department, and Ann was assigned to the case.
Okay. Can you tell us a little bit about the case? I know that some of the issues around the case are still pending, but can you give us a little bit of information about the case in itself?
Sure. Joel plays youth ice hockey, and he started when I believe he was about 7 or 8 years old, and he started in the Learn to Skate program and then progressed from there to Learn to Play, and then started playing on a team. When he first began in Learn to Skate, he was quite young, and at that level of ice hockey, it's very much just demonstrating different aspects of what to do on the ice. But then as you progress onto a team, there becomes a lot more oral presentations, explanations. They get into the game strategies, and reasons why you're doing what you're doing. And as the verbal explanations became more, he was getting less and less information, and was becoming very frustrated on the ice. We could see that just by watching him play.
Okay, so he actually can play, but the principle of the matter was if they wanted to communicate with him verbally, they had some type of break in the communication?
Right. No one ever said he couldn't play.
Okay.
But he was not, in my opinion, was not getting as much out of the program as he could have been had the accommodation been made.
Okay. Now, was the hockey team coordinator not willing to make the accommodation, or were they ever aware of the accommodations in the first place?
Well, this was the first occasion where I had ever requested an accommodation, so I was new at this too. And I anticipated that there would be resistance on their part, and so I kind of tried to ease them into it, and I mentioned early on in the season, in September, that it was looking like Joel may well need an interpreter because he was getting less and less out of what was being said. And there was the person I mentioned it to, who was the director of the organization, had a rather negative response to me.
Okay.
And then finally I made a formal written request in January of 1997.
So, in other words, this particular division of hockey or whatever was not accustomed to working with or having on their team a person with a disability.
It was a first.
Okay. Okay.
As severe a disability as Joel's. They had already dealt with kids with learning disabilities, you know, who had attention problems.
Okay.
But I think that was probably the extent of their interaction with.
Okay. And that probably is the hard part, that if it's the first encounter of any kind, people are just not ready, you know, but they weren't willing to seek out what services to utilize to help in making this a very easy and more accessible situation than just to say, oh no. So they almost just like threw their hands up with the idea of making accommodations, or did anyone ever seek out what the type of accommodations would be?
Well, they never contacted me at all. I wrote them multiple letters. They ignored every letter I wrote. I never got any kind of response from them. And my impression was that, well, if we ignore it, it'll go away. And that's not my nature, unfortunately.
Okay.
So,
Fortunately.
whatever the case may be. But no, they got the recommendation that they received was from their president, who happened to also be an attorney, and he informed the board that he did not feel that they had any obligation to provide an accommodation.
Okay.
And so that was where the problem began, I believe.
Okay. Well, that's different. Okay. So it comes to a point where there's an attorney and an attorney have to discuss the matter of what is appropriate accommodations and what isn't.
But I also think that in addition to there being a discussion, Marcia, about what the appropriate accommodation is there is what I think we run into a lot in this type of case, and that's a reluctance on the part of the entity being asked to accommodate that first person because of their concerns about financial considerations, or their concern about if we accommodate this disabled person, you know, they give like the sky is falling, what I call the sky is falling argument. If we accommodate this person, we're going to be inundated. And I think that that's an unrealistic response because there's a limited number of people, of disabled children that are going to play for this hockey program. And within that limited number of children, how many of them will be hearing disabled and need an interpreter? So I think that to use that kind of an argument in response is to throw the issue off of what's really important, because the courts say you look at the facts of the particular case in front of you and you don't be concerned with speculative cases in the future.
Right. You're so right. Well, I tell you what, ladies, we're going to come back, go away for a minute and have a commercial break, and we'll be right back.
Mr. and Mrs. Jones, Sally's having some behavioral problems.
I guess that reward system isn't working.
Well, the timeouts weren't either.
You know, parents do find that timeouts aren't...
See?
Well, you're just too lenient.
Well, you're too strict.
No, you are.
No, you are.
No, you are.
No, you are.
When adults don't have the answers, they can feel as frustrated as kids. ConnectForKids.org has thousands of resources for helping kids in your community.
Too strict. You're too
ConnectForKids.org, guidance for grown-ups.
Hi, and welcome back to the second half of the show. For those of you who are just now joining us, our show is Your Civil Rights with our guest, attorney Ann Warner, and her client, Claudia and Joe Kozlowski. Now, Claudia, we left off with some very good information here about the case, and I just want to ask you in general, how is it that the board for the hockey league decides how does accommodations come about or not, or do they make a decision like that?
They have to decide whether or not they will or will not accommodate, and in this particular case, they were advised by their president/attorney that they had no obligation under the law to accommodate, and I disagreed with that, having read the law myself, and this is how we ended up filing the complaint with the Civil Rights Department.
Okay. Now, what I'm hearing is that if they have attorney slash legal person doing their business, how is it that he or she would not be aware that this should be considered as an accommodation? Accommodation should be considered. I don't understand how that person, as an attorney, would make a decision like that without thoroughly investigating the law books or the
Well, let me
changes.
jump in and answer that, Marcia, because this is a case, what we attorneys call a case of first impression. This particular type of case has never happened in Michigan before. So this for me is a dream case. Every attorney in their career wants to do a case of first impression and try to make some new law. If this case prevails, ultimately, it will make new law in Michigan. Amateur sports organizations have not yet been found to be public accommodations in Michigan. You must be a public accommodation to be covered by the Persons with Disabilities Civil Rights Act. Because it's a case of first impression, there will be disagreement as to whether or not the decision's going to go one way or the other. So he looked at the law, saw that there was no law in Michigan, and took a position, which is a reasonable position, based on the state of the law at that time. However, we respectfully disagreed, and I will say I think the law is going in the direction that the department wants this case to go in, because the Little League has been held to be a public accommodation and therefore must accommodate disabled children who want to play Little League baseball. That's on the national level. Because the National Organization for Women sued Little League in order to allow girls to be able to play under a federal civil rights
But let
law.
me jump into that, and I'm just saying, why do we have to wait, and whether it's first impression, second, or whatever, why do we have to wait to develop a law that says children who, on the average, grow up wanting to play, be active, involved in community services, involved in sports activities of any kind, have to be used as a pawn to develop a new and improved law? I mean, you know, we're talking about a child here who eventually may want to become a pro hockey player or in any sports. And if we have baseball players who are hearing impaired or profoundly deaf, we can have hockey players. If we have bowlers or chess players, what is the big deal, ladies and gentlemen, about letting our children be children and growing up into the system being what they truly want to be without discrimination?
Well, that's of course why the department is handling this case, because we agree that that's the way it should be. But law develops over time, and when a statute is passed, it needs interpretation by the courts. We're hoping that the statute, of course, will be interpreted for a victory on our side. We have a recent precedent because the Minnesota Department of Civil Rights recently settled a case almost exactly like Joel's case. A profoundly hearing impaired young man who wanted to play amateur sports in Minnesota, and his mother went to the Minnesota Department of Civil Rights, as Claudia came to us, and filed a complaint. And before it even got as far as this case has gone in Michigan, the case was settled, and the sports organization is paying for a sign language interpreter for the young man in that case. So it goes on a case-by-case basis because each state has a different civil rights law. But just because the law develops over time. However, I don't see Joel as a pawn. I see him as a hero. I see him as somebody willing to, he and his mother, his entire family, as willing to step forward and help make new law in Michigan by taking this courageous move, because I know it has not been easy for the family to come forward and do this. Claudia did a lot of volunteer work for this sports organization. She was a hockey mom in every sense of the word before this case came
Okay.
to the Department of Civil Rights, and I'm sure that tension has developed in her relationships with a lot of the other parents because of the courage in coming forward. So it's a case of first impression, but Joel is not a pawn.
I'm sorry about using that statement, my statement, but I'm saying, in other words, I don't want to find out that a child's not a part of the system, you know, wholeheartedly, and they don't know. They don't understand why. A child is a child. They don't understand why all of a sudden mom has to do this, dad has to do this, or the impact. So I want to ask you, Claudia, is there an impact on Joel, on how he feels now about playing hockey, or has this case?
Absolutely. Absolutely. What drove me to finally making a formal request for the accommodation was that he became so frustrated that during the middle of a practice, he would remove himself from the ice and just go sit on the bench because he didn't understand what was going on. And then he would get in the car, I'm sorry, and on the way home he would start to cry because he didn't understand what was going on.
Okay, I understand. See, and that's a lot. That's a lot for a child to have to go through.
And all he's asking for is the same level of communication as anyone else. What struck me was that the opposition in this case and their attorneys have been arguing that Joel wants something special. And I keep trying to visually say, well, if everybody else has communication at this level and Joel's here without the interpreter, but an interpreter brings him up to where his communication is the same as the other children, that isn't asking for anything special, that's asking for something equal. And that's what civil rights laws are all about, equal.
I should say equal is way better than, you know, saying what is considered special. I mean, what is so special about asking to be taught and to be trained or to be understood in the same way as anyone else? You know, that is very difficult to digest, as though it doesn't matter. So it's like pushing this person to the side and, oh, we'll get back to you. And I'm sure that as the sign language industry increases every day, there's so many interpreters now that, you know, we have to be grateful that people are willing to take this job on as an assistance to the profoundly deaf and hearing impaired community, because I'm sure way back in the day and whatever that day may have been, there wasn't any assistance. To me, this is a new era for new jobs, new created jobs that help other people.
Well, and Marcia, and also, I don't know what the situation here is in Detroit, but we actually have a shortage in Grand Rapids of qualified sign language interpreters. There are sign language interpreters, and then there are qualified sign language interpreters, and we can always use more qualified sign language interpreters.
Okay. Well, I'm sure with that message alone, our listening and viewing audience will definitely give us a call and let us know if they can help out in any supportive way. And, you know, if you have to write letters to Congress or Lansing and things like that, that is always a support method, because I'm under the impression that they're everywhere. I'm under the impression that you can get service just about anywhere. But it's cases like yours, Claudia, yours and Joel's, that bring to the attention to the public that somewhere in the globe there's a problem. There's a problem with the actual accommodations for persons with disabilities. Yep, and it's not right.
And Marcia, in the course of working on this case, I discovered that there's actually a sign language interpretation service that specializes in sports.
Okay.
And I'm sorry that I didn't bring that information today, but I will get that to you if any of your viewers would like to be aware of that. These are interpreters who can skate or ice skate, because, see, Joel's interpreters have to be people who can ice skate and people who understand hockey terminology. So by having a special interpreter service that specializes in sports, depending on the sport, a parent and child can go directly to them and get somebody that's already well-versed in that sport. So you're right that interpreters are becoming more in demand, and I think that they will start to specialize more like that in the future, too.
Yeah, and they should. You know, we did a show not too long ago, and I asked the director over in Sign Language Interpreter Program about hospitals. They don't really have them in the hospitals, and the average nurse, and I'm not trying to talk down to nurses, but they will say, oh, I can understand, they can read my lips. Not all persons with hearing impairment and profoundly deafness communicate on the exact same level, and it is not fair for that person to be subjected to a person saying, I can do this. If you're not trained professional, if you're in training, tell me you're in training. If you're not a trained professional, please, seek me someone of a profession, because one word could be interpreted two different ways, and that's scary. That's really scary. And I'm glad that we have the ADA laws, and then they're locked in now with the Department of Civil Rights, and that's a wonderful thing. And Claudia, it takes a courageous parent like yourself with a good, strong son to seek out the service of civil rights and go forward with this type of situation, because some people would just say, oh, well, and I see you're a strong, determined mother who oh, well, doesn't fit in your vocabulary, which is great. Yeah, well, and I know that Department of Civil Rights is very proud of you in this aspect, and we're glad you came to tell us about the Civil Rights Department. Is EEOC a part of you all, too?
No, the Equal Employment Opportunity Commission is a national counterpart to the Department of Civil Rights, and they handle employment cases for the federal government under Title VII of the 1964 Civil Rights Act, which is a national law that governs employment discrimination.
Okay. Well, we're definitely going to give out those phone numbers again, so we know that if anyone has any questions in reference to their civil rights or want to contact your agency to have your office comes out. Now, is it a particular location is it the 1-800 number? Does it cover across the board in Michigan? Or?
Yes, it does. We have several offices throughout the state, and if they call our 800 number, they will get the office closest to where they're calling from. We have a system that's set up that allows people to do that. You want me to give that 800 number again?
Sure. Please.
That's 1-800-482-3604. We also have a TDD number, 313-961-1552. And I'd like to give our website again, because there's a lot of useful information on civil rights. That's www.mdcr.com.
Okay. Well, Claudia, do you have any closing remarks for us at the end of the show? And
I don't. I'm sorry we didn't get to talk to Joel, though. He's here, and I should have let him answer how he felt.
Okay, well, Joel, you can, if you want to, Joel can sign for us, and we can have our interpreter tell us.
Don't really have anything to say. I'm just kind of observing here. I've seen what my mom has said. I know we're just here talking about the court case, so.
Do you still want to play hockey?
Don't want to play hockey. Don't want to. Yes, I still want to play hockey. I think 6 or 7 or 8 years I've been playing now, so it's been a long time. So I'm continuing, and I don't want to quit. I don't want to play any other sports. When I was younger, I played baseball and soccer a little bit. But, yeah, when I was little, I played soccer. But then we moved, and it changed. Before, I played inside soccer, not outside soccer. It was too cold outside, and it was raining outside, so I decided I didn't like that sport. My brother played soccer, too, but it was inside soccer. So I saw my brother playing hockey, so I wanted to play hockey too. So I joined the hockey league, and I was really very interested. I like to play hockey. I've been playing for many years now.
Well, thank you, Joel, for that comment, and we wish you well. Okay. Well, ladies and gentlemen, this was a very unique show for us today, and we hope that you tune in. Please call the Civil Rights Department if you have any complaints or any comments or concerns, especially if you think for sure that something has gone wrong within your situation and you need to have it addressed or just to have comments or questions answered. We also would like to thank our interpreter, Laura Jones, from the Statewide Services for the Hearing Impaired. We thank her for being our interpreter today. And you know who I am. I'm your host, Marsha Florence, for Just Ask. As I always say, if you know someone with a disability, don't be afraid to ask, just ask. I'm your host. Thank you.